Well, good afternoon, everyone, and welcome to Terrapin Love Week. My name is Christine Kunkel. I'm the Associate Director of Alumni Events and Professional Programs at the University of Maryland Alumni Association. We are pleased you're able to join us for today's session, Protecting the People and Places You Love, an Estate Planning Seminar. We are so fortunate today to have alumnus and attorney Jeremy Rachlin and Executive Director of Gift Planning Patty Wang to share their expertise and advice about estate planning with you all. Please submit your questions for them using the chat box located at the bottom of the Zoom panel. This session will be recorded. If you don't wish to appear, please simply turn off your camera. And now I am delighted to introduce our speakers. Jeremy Rachlin is class of 2002, chairs the Estate and Trust Practice Group at the Bethesda, Maryland law firm of Bulman, Dunie, Burke, and Feld. He provides estate planning, trust administration, estate litigation, and probate services to clients across the state of Maryland and the District of Columbia. Jeremy has been recognized by Maryland Super Lawyers magazine as amongst the top 5% of Maryland attorneys each year from 2012 through 2021. He has been recognized as a top estates attorney in Montgomery County, Maryland, and presently serves as an executive officer of the Montgomery County Bar Foundation. As a member of the University of Maryland alumni community, Jeremy proudly serves on the College of Behavioral and Social Sciences Alumni Board and is Vice President of the Gemstone Honors Program Alumni Board. Patty Wang's career in higher education fundraising has been in service of the University of Maryland since 1986 in frontline fundraising and development operations. She transitioned to gift planning and estate administration in 2006 and currently serves as the Executive Director of Gift Planning. Patty is a past president of the National Capital Gift Planning Council and was their 2019 recipient of the prestigious Distinguished Service Award, which is the highest recognition given by the council. Patty received a bachelor's degree from California State University, Los Angeles. Now let's get started. Jeremy, over to you.
All right, good afternoon, everybody. Thank you so much to the Alumni Association for having me. My name is Jeremy Rachlin. I graduated in the class of 2002. So my senior year was a fun year. Won the national championship in basketball, Orange Bowl, and football. Most importantly, Ellicott 7, Charles Hall. I want to thank you all for being here today. When I looked at the programming on Terrapin Love Week, I noticed that we've got our presentation today on estate planning and then one coming up on putting the spark back in your marriage. And I didn't know how I would possibly compare to that, but I'm grateful to you all for being here this afternoon. A little bit about me, just besides what you've already heard, I'm in a double Terp family. Married to a Terp. We have a 10-year-old daughter who's dying to be a Terp, and I'm learning very quickly that admissions isn't the same as it was in the 1990s when my wife and I were coming through. Now, this is a presentation that I give pretty often to folks. It really focuses on just the nuts and bolts of estate planning, really just the core fundamentals of estate planning. My goal today isn't to dive too far into the details, but really it's to help everybody walk away understanding how you really can protect your loved ones from being in a really difficult situation, either during your lifetime or after you're no longer with us. As Christine said, please, if you have questions, use the chat. I will try and get to questions as much as I can at the end. And I will also provide my contact information. So if there's any questions that you have that are personal or that you don't necessarily want to share with the whole group, I get that. Families are complicated, estate planning is complicated. So feel free to shoot me an email and I'll provide that contact information. With that being said, I am going to do my best to share my screen. All right. All right. Okay. It is very slowly coming up. I apologize. Here we go. All right. All right. So, for starters, estate planning really isn't just making a will or a trust. Every time I sit down with clients to begin with, which is just to kind of begin the discussion, I want to be very clear that when we talk about estate planning, we're not just planning for death. Yes, that's a big part of it. But so much of the planning that we do, so much of planning to protect those who we love, involves planning for incapacity. And I would say this, I think, and it's really sad and tragic, hundreds of thousands of folks this past year, came face to face with the fact that, incapacity can strike quickly, and you really can't plan for a crisis once you're already in a crisis. So the most important thing you can do is get ahead of it, engage in some estate planning, plan for incapacity through powers of attorney. And then there's also planning that you do to plan for post-death planning, basically who is going to inherit, what will folks inherit, and who's going to be in charge of that process. So, first things first, planning for incapacity. The first component document is a healthcare power of attorney or an advanced medical directive. And there's actually two parts to a healthcare power of attorney. So the first part of a healthcare power of attorney is an advanced directive. Essentially, that is a document that says when you can't speak for yourself, when you can't consent to treatment, when the doctors need somebody to authorize treatment on your behalf, who can speak for you? That's an advanced directive. That's the first part of an advanced directive. So, what sorts of decisions might a healthcare agent make? I mean, it can be everything from treatment, placement, surgery, scope of intervention. And that kind of dives into the second part of an advanced directive, and that's a living will. A living will is the part of the advanced directive where you essentially can talk about your end of life goals, your end of life values, what kind of intervention you would want to extend your life in the event of a terminal condition. Cheery stuff, I know. But that's the document in a nutshell, and the types of decisions a healthcare agent might make. And I'll also mention, this has kind of come first and foremost, or really kind of to the forefront of national consciousness lately with COVID vaccines. There are folks who are in memory care facilities who have Alzheimer's and other cognitive issues who can't, who they're having trouble vaccinating because they need to get consent to give the vaccination. And absent an advanced directive on file, they're finding that there's some difficulty to actually give that vaccination. Now, the big question, anytime you're talking about a power of attorney or a will, who should you appoint? Who should I appoint? Can I have co-agents? Should I have co-agents? And I tell folks I come to this from a little bit of a different place than many estate planning attorneys. I spent the first 6 years of my practice after law school exclusively litigating estate and trust disputes. So really, when I wasn't doing planning, I was involved in court when stuff was going sideways. And so I tend to approach these sorts of decisions with that in mind. I guess having seen the conflicts that folks have found themselves in and trying to avoid those conflicts, because after all, what's the point of going through estate planning if you're just going to find these documents creating more conflict down the line? So who should you appoint? Obviously, it should be somebody who shares and understands your values. You can also, and in fact, you should appoint both an initial agent as well as a backup agent. So oftentimes, folks will appoint a spouse but then they'll appoint an adult child as a backup agent, because what we don't want is we don't want to go to the trouble of creating this document and having a vacuum, having nobody who's actually there who's able to serve. So that's, we want to make sure that we have somebody kind of, who's going to be available. Can you have co-agents, and should you? Well, the first question is yes, you can, but the bigger question is, should you? Because what we don't want, when you think about it, theoretically, this is a document that gives the doctor or the medical professional a clear, bright line. This is who can speak for the family. This is who can speak for the person who can't speak for themselves. So if you have two different people telling Dr. March East and one telling Dr. March West, and there's a log jam, it's going to be a really, really bad situation. So, should you have co-agents? That is a question for each client in terms of, are the co-agents who you're thinking about unequivocally going to get along? Another thing that I talk about when we talk about who should you appoint: calm under pressure. These documents aren't going to be pulled out on a good day. It's not going to be a good day. We want somebody who's going to be calm in the face of a crisis when everybody around them is likely losing their minds. Now, what if you don't have one? Okay, we just talked about why you should have one. This is really kind of the one area where there is some backup, there is some leeway. If you don't have one, there are Maryland healthcare surrogacy laws that would, for example, allow a surviving spouse to make decisions. It's not as robust, though, as what's in an advance directive. So I'm going to, in the chat, when I'm done speaking, place a link, free link, straight to the Maryland Attorney General website. There is an advance directive, a fillable PDF that you can complete this afternoon. Now, it does need to be notarized and witnessed, but I'll put it in the chat box when I'm done speaking, and it is there. It is a link to Maryland's form of advance directive. Now, who can pay your bills, right? We've just talked about healthcare decision making. Well, I like to talk about the healthcare versus the finance. One can authorize somebody to talk to the doctor. The other authorizes somebody to pay the doctor. A Maryland statutory financial power of attorney is essentially, it is a broad-ranging document that grants an authority or an agent wide-ranging authority with respect to your assets, your resources. So, what sorts of financial transactions might an agent engage in? Lots. This is a broad document. I mean, I have worked with powers of attorney when a loved one is no longer going to be at home anymore. Getting the home sold, accessing retirement. You can make early withdrawals from retirement to pay for medical care. Updating beneficiary designations. If you come to realize, and we'll talk about beneficiary designations in a moment, but if a beneficiary designation is no longer current, really anything that you can do with respect to bank accounts, real estate, retirement, insurance, that's the kind of thing that your financial power of attorney can engage in. Now, again, question: who should you appoint? Can I have co-agents? Should I have co-agents? This is really a place where I'm fond of saying estate planning is not the place for family diplomacy. I work all the time with clients who have multiple children and feel very strongly that they're going, and greatly fear, that a child of theirs is going to have hurt feelings if they're not included in the document. And truly, it can be, you can find yourself and your family in a far greater place by nominating somebody who has no place being in that document than by not nominating them at all. Or what you can do is you can make them a further backup. So if you have, 2 or 3 children, and you know that there's one child who you really trust with your money, and there's one who's not the best, well, you can say the first agent is going to be the one who I trust implicitly, and then a backup agent. But I would question whether that child has any business being in your financial power of attorney, because as I've explained, it's such broad authority. What if I don't have one? This is not as forgiving as a healthcare power of attorney. If you don't have a financial power of attorney and there needs to be a transaction involving your property, a family member is going to have to go to court and obtain a guardianship over your property, which is a lengthy and costly process. And there's really no way around it if you don't have a financial power of attorney and there's an asset in your sole name that somebody needs to access on your behalf. So, just like a healthcare power of attorney, I will actually, when I'm done talking, put a link in the chat box. Maryland has a form financial power of attorney. I will put a link in the chat box and feel free. It is unlike the healthcare power of attorney. It's not a fillable PDF, so it's not as easy, but you can print it out and complete it at your leisure. All right, shifting gears. Shifting gears. So we've talked about planning for incapacity, healthcare, and financial powers of attorney. Now we're going to shift gears and talk about post-death planning, estate planning, planning for what happens to your resources after you pass away. So the thing that I would say about probate is there's a lot of attorneys out there who put on seminars and really ramp up the fear factor in folks about probate. I would say that probate, it's nothing to fear. It's administrative, it's bureaucratic, involves court filings. It's just more as I say, headache in a time of heartache. You're in this administrative process at a time when you and your family have just suffered a significant loss. But the good news about probate, the good news and the most important thing to take away is not everything that you have is going to be part of probate. In fact, I would say that most of the assets that you have, if you're the first spouse to pass, aren't going to go through probate. So let me explain. Assets which are not included in probate, assets which you own jointly, are not included as part of probate. They pass directly to the surviving joint owner. So, for example, you own your home with your spouse and you pass away. That home passes directly to your surviving spouse. You're joint with your spouse in a bank account and you pass away. Control of that account directly to your surviving spouse, directly to your joint owner. Assets which have a beneficiary designation on file don't pass through probate. And when you think about it, we put beneficiary designations on our retirement accounts, our 401ks, our 529s, life insurance. We put a beneficiary designation on it. In fact, most of the time we have an initial beneficiary and a contingent beneficiary. Any asset which does not have a beneficiary, any asset which has a beneficiary designation does not pass through probate. The asset goes directly to that beneficiary. The only assets which are going to go through the probate process are assets that are titled in your sole name, which do not have a beneficiary designation attached to them. So quite commonly, when I'm working with married couples, when the first spouse passes, there's very little in the way of assets that actually go or are part of the probate process. It's much more common when the second spouse passes that we're dealing more in probate court. That is that's the probate process. It involves essentially filing the decedent's will, the decedent, also known as the person who passed away, inventorying the assets that are part of probate, and then ultimately accounting under the supervision of the probate court for how those assets are disposed of. Essentially, the probate court supervises that those assets are dispersed however the will says. Now, assets which are included in probate, who's in charge? How does the person distribute the assets? The person who's in charge of probate is called the personal representative, Many states call it the executor. Most folks are more familiar with that term. Here in Maryland, we call that person the personal representative of your estate. And how does the person charged ultimately distribute the assets? However, the will says. Now, why is it important to have a will? If you don't have a will, the laws of intestacy apply. And the laws of intestacy are essentially a default, which states that how somebody's estate is to be divided. I'm dealing with this right now, actually. A gentleman in his late 50s passed away suddenly last month, and he didn't have a will. And it's quite clear that and he'd been married for 20 years, and it's quite clear that he intended for all of his assets to go to his wife, but there are substantial assets that he owned in his sole name that are part of probate. And when he doesn't have a will, the law of intestacy, basically the law of heirship, applies. And what that means is his spouse gets half, and his 10-year-old son gets the other half. And there's all sorts of issues at play, as you can probably imagine, with a 10-year-old son inheriting a home. What do we do with the home? But this is why it's so important, because having a will allows you to deviate from the law of intestacy, because the law of intestacy, while it's important, we need to have a default, can lead to some very, very, very unpredictable, unexpected, and unforgiving outcomes. So, what are the requirements of a will, and when should I consider an update? So, this is really important. Every state differs in terms of the requirements of a valid will, but we're talking about Maryland today. So in Maryland, you don't need a notary. You don't need a notary. Now, a lot of times we will actually notarize wills, because some states do require notarized wills, but Maryland does not require a will to be notarized. All that's required is that the will be in writing and signed in the presence of 2 adult witnesses. And everybody has to be together. In other words, the witnesses have to witness the person signing the will and have to witness each other witnessing. So, there was a brief period during, I guess, the early parts of COVID, when some of those rules were relaxed and we were allowed to actually do things over Microsoft Teams. That no longer is on the table. So everybody's got to get together. Most estate planning attorneys, myself included, doing socially distanced signings. But that's what's required for a valid will. Now, many clients already have planning, but we've been talking to a lot of folks the past 12 months who want to review their existing estate planning. So, if you already have existing estate planning, kudos to you, and kudos to you for being here today. What I would encourage you to do is take a look at really 2 key things. One, who are the folks who are nominated to serve as your power of attorney, to serve as your personal representative? Do you still want them to serve? Are they still fit to serve? Has there been a change in that relationship? Because, as I said, families are complicated. We get that. But the other thing that we're seeing is, a lot of folks did estate planning 20, 30 years ago when their children were 2, 3, 4 years old, and now their children are adults. And so it's a good time to update to include those children. A lot of times those older folks have siblings or parents who are no longer able or around to serve. So those are really the kind of the things that I suggest that you look at if you already have existing planning. Really key in on who the folks are who are nominated to serve. Assets and tax law changes. That's a big thing I'm going to get to in a moment. But if your assets have gone up substantially since the last time you did your will, that might be something that you need to consider as well. Something else that I just realized that I did not mention that's critically important as part of this presentation in terms of protecting the people you love. So as I mentioned at the outset, I'm a double Turk family. I've got a 10-year-old daughter, and I'm particularly attuned to this, and I think many young families are particularly attuned to this. One of the most important things that a will can do in Maryland, a will can be used to nominate a guardian for your child if you and if the parents are unable to have custody of the child. And essentially why that is so important is Maryland law has a chain of priority for who can serve as guardian of a child. And first in that chain, obviously, is a parent. Second in that chain is somebody who's nominated within a testamentary document, such as a will. So if there's somebody who's really important to you to raise your child, if you and your spouse or you and the other child's parent, the other parent can't, a will is the place for you to nominate a guardian. Talk about protecting the people you love. That's about the biggest protection you can give within a will. All right. Now, protecting the people that you love. Am I going to leave behind a big tax burden? Everybody wants to know that. What are taxes going to look like? So, one of the wrinkles about inheritance in the United States, as opposed to a lot of other countries, is that absent very limited circumstances, beneficiaries, the people who will inherit from you, actually are not taxed. It's not considered taxable income to them. What is taxed is your estate as a whole. If anything is taxed at all, your estate is taxed, meaning that there's funds that are paid off the top in tax, but then the assets that pass that are inherited are generally inherited tax-free, which is big news to a lot of people and really different than a lot of other countries. Now, big thing to bear in mind here is each state differs. Each state differs, but I'm going to again focus on Maryland. So what is the estate tax? And I'm going to keep this as brief as I can because I don't want eyes to glaze over. But estate tax is essentially the tax that's assessed against the estate for distributions in above an exempt amount that don't go to your spouse and don't go to charity. So let's parse that out. You can leave behind an unlimited amount to your spouse. Now, you can also leave behind an unlimited amount to charity. Now, for those who are not a surviving spouse or charity, there's an exemption. And anything above that exemption that's part of your taxable estate is taxed. Maryland, there's a $5 million exemption presently. Everything above that is taxed at 12 to 16%. Federally, we have a huge number. There's an $11.58 million exemption right now. The tax rate, though, is huge. It's a 40% federal estate tax. And the other thing to keep in mind, the next bullet point is we just talked about how very little is actually included in probate. Well, what's included for what's called your taxable estate is essentially everything, probate and non-probate. Anything that's under your control at the time that you pass away. So that can include life insurance, that can include retirement, that can include jointly held real estate, other assets that, although they're not part of probate, will be counted as part of the resources that you have when we're adding up what your taxable estate is. Now, as I mentioned, charitable gifts within your estate planning documents don't count against your estate tax exemption. So I'm going to put in a plug for Maryland right now. We certainly do work with folks who make charitable gifts as part of their estate planning documents to educational institutions, religious institutions. I did a seven-figure gift recently for another Big Ten institution that started with M. Unfortunately, not Maryland, and I joked with the client that she needed to check very carefully because I might change the school. I joke. But you can also engage in lifetime gifting to reduce the resources. Again, the old adage, you can't take it with you. Charitable gifting, lifetime gifting is a very popular way for folks to reduce their estate, the resources that are going to be taxed. The big thing that I want to keep in mind is, estate tax law is something that's it's not settled. There is some degree of flux here. So I told you, Maryland is 5 million, federal is 11.58 million in terms of the exemption amount. And again, everything above that exemption is taxed, everything below that exemption is not. Well, what we're seeing, governments are broke. COVID is breaking the bank. In DC, the DC government has actually already reduced the estate tax exemption in DC. Whether that's going to happen in Maryland, I don't know. But we are seeing it happen in certain states. We also expect that at the federal level, we have this huge $11.58 million exemption. We expect that's going to come back down closer to the state level at 5 million sometime within the next few years. So that is something that we do we encourage you to listen when you hear about estate tax. And the reason I talk about this is so that if you hear about estate tax, maybe you understand a little bit better what it is and how it might impact you. So I'm gonna, before I turn it over to Patty, top 5 estate planning tips with my all important attorney caveat here. So, number 1, remember about your beneficiary designations. Remember your beneficiary designations. You can use those beneficiary designations to avoid probate, but you always should remember, you always should keep in mind the assets that you have and who the designated beneficiaries are. And please, 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 if you go through a divorce, update your beneficiary designation. I have been involved in cases where spouse number 1 was still the beneficiary, and spouse number 1 was not the surviving spouse at the time of death. So update those beneficiary designations, but use them to avoid the probate process. The next one, having a power of attorney doesn't mean you give up control. Really what you're doing is you are planning for the people who you love. You're planning for the people who you care about. What you're doing is you're retaining as much control as you can over the process. When you don't have control, you're retaining control over who is going to make decisions for you and who is going to protect you and protect your assets. Number 3, create a cheat sheet. This is kind of important, and now's a good time to do this. So what do I mean by cheat sheet? I'm a big believer in having your estate planning documents someplace safe in your house, not a safe deposit box. I have a small metal filing cabinet. And what I recommend to folks, and actually having gone through this with my own family, where we had a family member get ill, is with those documents, have a cheat sheet on hand. Picture a situation where somebody has to essentially parachute in and manage your finances. And that person may have absolutely no idea what it is that you have. So, what should be on this cheat sheet? It's never going to be a perfect list. But what I recommend to folks is a listing of accounts, account numbers, designated beneficiaries on those accounts. If you have online banking, login and password, and keep that, and everything, email password, iPhone password, because God knows, we email and phones run the show these days. And nowadays, we're at kind of at that point in the year where 1099s are coming out. And it's a good time to really either create that list or update that list. And, you don't need to keep balances on there, and you certainly don't need to share that information with your agents. But, I recommend to folks, when you tell your agents, this is where you can find the documents, you also tell them that with the documents, there's going to be information there that they need. Taxes, probate, and powers of attorney vary by state. This is actually very important. Each state does have its own forms, its own tax laws, its own probate procedures. It's not to say, make no mistake, it's not to say that if you create Maryland documents within the state of Maryland and you move to Wyoming, suddenly you don't have documents. That's not how it works. If you create documents that are valid under one state's law and you move, those documents will continue to be valid. But the question is, are those documents optimized to take advantage of that state's particular tax laws, procedures, and power of attorney laws? So I in this area where we've got, my office in Bethesda, 2 miles the crow flies from DC, 4 miles the crow flies from Virginia, and folks are moving. I do recommend to folks, if you have existing documents and you've moved, it's a good reason to consult with an attorney in your new new state of residency. Finally, special care should be taken for blended families and late in life romances. This is the former litigator in me talking. There's an old saying that the best source of business for estate and trust litigators is blended families. I don't think it comes as much of a surprise here, but this is really something where you really want to take a measured approach, and talk and have a candid conversation with an estate planning attorney. Is there a prenup involved? How do we want to plan to make sure that both sets of children, if applicable, are protected and feel like they're taken care of? So I just include that in here because it is somewhat common around here. So those are my top 5 tips. So I really appreciate the opportunity to speak. I really do. It is a pleasure. I mean that to speak to the Alumni Association and to speak at an event sponsored by the Alumni Association. Please feel free to reach out to me if you have any more questions. My email is here, my phone number is here. I'll put it all in the chat box, and I will also put the link to the powers of attorney in the chat box. And I'm sure I'll be talking more at the end. I'll be happy to answer any questions, but for right now, I'm going to turn it over to Patty. So I'm going to stop my share, mute myself.
Okay, thank you so much, Jeremy, and to the Alumni Association for having me and Jeremy here today. Jeremy has really covered some really great points for why it's important to have an estate plan and a will. I think one of the main things that he has really hit upon has been you want to be making these decisions for yourself and your loved ones, not to have a judge be doing that. So before we start with my short portion of the webinar, I just wanted to again say hello. I'm Patty Wang. I'm the Executive Director in the Office of Gift Planning at the University of Maryland. I've had the pleasure of helping many, many generous donors, friends, and alumni to incorporate the university into their estate plans. It's been a real honor and a privilege to do so. I am not an alum of the University of Maryland, but I consider myself honorary, having been at Maryland for my entire career. My husband is a faculty member at Maryland in the Clark School, and I also have 2 adult sons who are both Maryland alums, also of the Clark School. So I don't have quite the connection that Jeremy has, but it's also a really strong one as well. I also wanted to give a shout out to Jeremy just because of the presentation of the nature of his material. It can be very complicated, but I think he's presented it in a very easy way to understand while stressing the importance of everything. So let me get to share screen with my areas now, and then we will start. Okay, wonderful. So he's talked about philanthropy as part of your estate planning, and this is kind of what we're here to talk about right now. So if you look back at 2020 from a philanthropic perspective, it was a banner year. A couple of reasons are that the uncertainty of the panic, as Jeremy said, gave many people pause to put their estate plans in place or to revisit those plans if they were already taken care of. Things change every day, so it's good to be prepared. There were also some stimulus packages that provided some tax-wise incentives for charitable giving, such as the 2020 CARES Act. And then last but not least, despite all of the challenges that we had, it was a confirmation, and I really love, this is my favorite reason. I think it was a confirmation of the human spirit and that people will reach out to support worthy causes, and they'll also reach out to help others in need during difficult times. So even though there were a lot of challenges and there are still challenges ahead, this third one is the one that kind of keeps, it's my sort of Northern Star for why philanthropy is important. We get a lot of questions about the Office of Gift Planning at the University of Maryland and what it is that we actually do. Some people know of our existence, others don't. We try to market and get the word out, and that's something that people can help us do, whether they're donors or alums. So we basically provide our alumni, donors, and friends with resources that will help in the planning of one's finances and estate. We're a service that's here to help with your philanthropic goals. We can suggest ideas, recommendations, depending on what you'd like to accomplish for Maryland. And those plans can be discussed with your own advisor. And in some cases, as Jeremy said, with or without your family members. It kind of all depends. It's very individual and unique. But the advisor can help determine if that idea that you're thinking of for Maryland might align with your financial and estate plans. And I do think that over the years, what I have seen has ranged from I really want to leave everything to my loved ones, so I'm not interested in charity, all the way to folks who have just said, I'm leaving everything to charity or to my cat. So it ranges a lot of things. Um, Most of the time, I think the folks that we assist often will say, I've heard Warren Buffett's, life has been good to me. I want to leave something to my family or my heirs, but not everything, because I also want to help charity. So the next point is something that's very important. It's something that Jeremy also pointed out to, is that gift planning and estate planning, it's not just about what happens after your lifetime. It's something that you can also incorporate during your lifetime. And he covered some of the things which are um, generating additional income for you during retirement or for your loved ones. You know, that's kind of getting into the weeds at this point, because this webinar is really focused on a bit more of a high level perspective on the whole topic. But what we want you definitely to be left with is that our gift planning office, and we have a team of folks, we'd be happy to walk through various options with you for you to consider, to discuss with your advisor, with your family, again, or not, at no cost or obligation to you. Okay. Again, you know, there are many different levels of charitable giving. What we discussed today was the most easy legacy gift, and those are the bequests and beneficiary designations. The important thing, again, to remember here is that these are revocable, meaning the plans can be changed. You would make a commitment now in the present day, but they would not become payable until after your lifetime. And I think what's wonderful over the years is that I have seen many people who have given loyally to Maryland on an annual basis in modest amounts. And they say, I would really love to do, you know, something more substantial, like an endowed scholarship to help students that would be around for years and years later on, but I just can't do that right now. A legacy gift is a way that one can make a much larger transformational contribution that may have been possible during one's lifetime. So it's always important to kind of really think about what it is that's important to you. Who are those people? You know, does philanthropy come into those plans? And if that's something that you'd like to think about, definitely it's something that we would want to be available to you to discuss. And Jeremy talked about the easiest ways that that can happen is a bequest by will or through a trust. It can be a dollar amount, it can be a percentage, or it can be an asset that we can make use of. The wonderful thing is you can control your assets during your lifetime, and you can change your mind anytime if your life circumstances change. The other thing is beneficiary designations. Again, Jeremy kind of covered this. What again is great is that these assets through beneficiary designations will, left to charity, will pass through tax-free to the charity. But again, if it's left in your estate, there's always a possibility that some of these assets, depending on the circumstances, could be taxable. What I've shown here is if this is something that you'd like to think about or discuss, not everyone is comfortable coming forward because they think, oh, you know, my kids are going to find out, they'll hate me forever. Or, you know, once I make a charity aware that they're in my estate plans, they won't leave me alone. So what we've done here is, this is the correct bequest language. So it's here for you if you're interested. And on the right, it's not legible on the screen. It's very small, but it is a one-page document that we can share with you on charitable bequests and beneficiary designations. It has the same bequest language right here in this gray box. And then the left column just tells you some of the benefits of bequests and designations. And we can make this one pager available to you for those who are interested after the webinar. Okay. And you can feel free to contact our office at any time, again, for a free, no obligation discussion, to explore options or almost anything. We have a website, which is under it's getting a facelift. It will be available again within the next week or two, but here's the address. You can write to us with any questions at all. You can call us toll-free at any time. So regardless of what state you might reside in, it's a toll-free call. Here's my direct information with my email, my office number, and my mobile number, so that you can contact us with any questions or assistance that you might need. We do work a lot with attorneys like Jeremy, and it's really important because we can then get all the players in the room at the table to talk about the plans that a potential donor might have, and to ensure and to give that person peace of mind that his or her wishes are going to be followed, whether it's through his or her estate and whether or not that includes a charitable component. So thank you very much for allowing us to present what the Office of Gift Planning does, in addition to Jeremy's great presentation. And I encourage you to think about the things that are important to you in your life. And if charitable giving is one of them, and giving to Maryland is another one, then you will be wanting to contact the Office of Gift Planning at some point. So thank you very much.
All right, so Christine, I think we have about 10 minutes left, and we have a number of questions in the chat that I'm going to do my best to tackle. First question is, does a will have to be registered with the state? No, you can, in the state of Maryland, deposit your will for safekeeping with the Register of Wills. It's a nominal fee, like $5 or $10, but absolutely not. A will doesn't have to be registered with the state during your life. However, when you die, your will does become a matter of public record. It is filed with the Register of Wills in the county where you live. And you know, you can, there is a database. The Register of Wills from Maryland has an estate search database, and you can type in essentially anybody's name. And if they have passed away and there's been a will that's recorded, you can click and order a PDF, and the will be delivered to you at 50 cents a page by email. So will does not have to be recorded until the person who created the will passes away. So obviously, you know, you can feel free to change wills during your lifetime, change bequests, change who the personal representative is, what have you. What about inherited IRA money? This is a really, really, really hot button issue that dives a little bit more into taxes and tax planning, but is incredibly important around here, where we we have a large number of retirement millionaires. I mean, we start contributing to a 401k, shortly after undergrad, and that can balloon over time. So inherited IRA money, I'm going to speak very, very briefly on this question. Basically, if a spouse is the beneficiary of an IRA account, the spouse can roll it over into his or her own IRA. If it's somebody besides a spouse, I think what you might be alluding to is the passage of the Secure Act this year, or last year. I'm sorry, I'm losing track of time. Maybe it was 2 years ago. And the Secure Act essentially requires folks, if they inherit an IRA, because they are a beneficiary designation, there's a beneficiary designation where they inherit as part of a trust. Essentially, there's a 10-year period. You can defer taking distributions from that for essentially up to 10 years. There used to be ways where people could defer distributions indefinitely through various trusts, stretch IRA trusts, and things like that. And the IRS realized that it wasn't collecting revenue at nearly the speed that they hoped. So the Secure Act came into play. And essentially, if you are a non-spousal beneficiary of an inherited IRA, there is an accelerated timetable by which you have to take distribution of the IRA, and that's treated as income to you. That is a difference. I know that I said most of the time what you inherit is not treated as income. Inherited IRA, it is distributed to you and taxed at your rate. Lots of questions about debt. I got probably 2 or 3, actually 4 direct questions to me with respect to debt and what happens when someone dies with respect to debt. And that's a very good question. So 2 types of debt. We have secured debt, which is essentially a mortgage, is the most common type of secured debt. Some type of debt that's secured by collateral. Unsecured debt is other type of debt, credit card debt. Those are the most common that I see, mortgage and credit card debt. So what happens to that debt? Well, if it's a joint debt, the debt continues to be an obligation of the surviving debtor. If it's debt in the individual's sole name who's passed away, then the recourse, if it's unsecured debt, like credit card debt, they can only pursue, generally speaking, there are some exceptions to this, but they can generally only pursue assets in the probate estate. So if the lion's share of assets are not part of probate, an unsecured creditor can really feel the bite of not being secured. A secured creditor, on the other hand, does continue to have security rights and the ability to enforce the debt against a house. So against a house, for example. So where I'm going at is this really comes into play where there's a home that's encumbered by a mortgage, and someone inherits the home, and they say, well, what do I have? What about the mortgage? And I say, well, the mortgage company still needs to get paid. Otherwise, they have a right to foreclose on the note. Now they might be restricted in terms of their ability to get late fees and things like that, but they still have a security interest in the collateral that they can enforce if they're not paid. So that's where things get tricky. But unsecured debt, credit card debt, chief among it, that can really be difficult for a creditor to pursue. All right. Looking down.
Jeremy?
Yes.
Can I go back to the question about the IRA beneficiary?
Sure, please.
So there are, again, this is getting on a little bit more of a complex level, but I'm sure that Jeremy knows that if this is something that you're considering, it's a little bit more of a maybe financial planning strategy as opposed to an estate planning strategy. But there are ways that that 10-year sort of limitation for someone who is a non-spousal individual where gift planning can actually help that situation if you're in the planning stages, or if you find out you're the beneficiary of an IRA, and it's the combination, it's getting a little more complex again, but there are some wonderful ways that we can kind of help alleviate some of that problem. So I just wanted to get that out there.
Thank you. And you're exactly right. I'd say that's estate planning 301. I think we're at 101 today, but you're exactly right. All right. So I'm going to take the questions a little bit out of order. From an estate planning perspective, would it make sense to add adult children as joint owners on deeds and bank accounts rather than as listed beneficiaries? So, I mean, from an this is a really complicated question, because from an estate planning perspective, um, if you add a child as a joint owner, the asset becomes theirs. So if you only have one child, maybe it's a little bit of an easier situation. But if you have two or three children and you want to name, this happens a lot, where somebody says, I don't want to make the person use a financial power of attorney. I just want to add them as a joint account holder. Well, unquestionably, it's going to be easier for that person. But the conversation becomes, you need to understand that in adding them as a joint owner, that asset becomes theirs when you pass away. When you add somebody as a joint owner on a deed, don't do that. There's so many reasons why that's dangerous. Chief among them, somebody who has an interest in real estate jointly with you can actually, if things go south in the relationship, can file a suit in court to have the property sold out from underneath you. That should be reason number one. It's called a partition lawsuit. But also there's other tax issues. Even if everything remains completely fine between parent and child, there's issues, and this is, again, I'm getting way to the weeds, but with step up in basis. Essentially, we want people to acquire an interest in real estate as far out as possible so that their cost basis is as high as possible. So that exposes them to less capital gains. So the question is, so the answer to your question is, sometimes it's appropriate to add people as joint owners on bank accounts. Rarely would it be appropriate to add them as a joint owner on a deed. Use a beneficiary designation for larger accounts as well. We're at 3 o'clock, I know. So one last question, and this is a biggie. A couple questions about trusts. So how do I talk about a trust in a minute? Essentially, a trust, right, Patty? I mean, wow. So essentially, a trust is an alternative to a will. It's the best way that I can put it. And if you title assets in a trust during your lifetime, a trust is a separate entity that continues to exist after your passing. So, real estate, for example, that's in a trust, it will never be part of probate. If I own real estate with my wife and I pass away first, it goes to her. But ultimately, upon her passing, it's going to go through probate. Now, if there's a trust that's involved, when we both die, that real estate will stay in the trust and won't be part of probate. Basically, a trust is another pot, another reservoir where you can put whatever assets you want into it and shield them from probate. The other advantage, as somebody asked, is a trust is private. Unlike a will, which, as I just said, has to be filed with the Register of Wills, a trust is not subject to public record. The only people who are entitled to a copy of the trust, generally speaking, are people who are beneficiaries in the trust. And the only time that I'm submitting a trust to the probate court is so that the probate court can review a trust, not to put it in the file, not to make it public record, but for tax purposes. So there are some advantages to it. A trust is private, and a trust can basically permanently shield assets from going through probate. Now, they're more expensive to set up. There's some additional legwork in terms of beneficiary designation and retitling, but it is certainly something that we talk about with folks, particularly couples a little bit later on in life. So we're at 3:02. I think I have hit I think all of the questions. Some people sent me direct questions, which I believe I answered. And I know I put my contact information in the chat. I will do it one more time, and I'm going to mute myself.
Well, thank you so much, Jeremy and Patty, for your time and expertise today. This was so informational and we really appreciate it. And thank you to everyone for joining us today. A copy of this video will be sent to you at the email you used to sign up. We hope to see you at another event soon. Thank you and go Terps.